Greetings, welcome to episode 6 of the Politics of Prosecution video series. This is the last episode in this series. We are going to wrap up by looking at how politics constrain prosecutors. So our first episode was an introduction. Our second looked at the political system. Our third looked at the criminal court system. Episode 4 looked at prosecutors. Episode 5 looked at how prosecutors can use politics for their advantage or their benefit. And this episode looks at how politics can constrain prosecutors in their work that they do. And in order to do that, we're going to look at both internal and external factors. We can go through the internal factors rather quickly, and then we will turn to the external factors where we'll spend most of our time here in this episode. For internal factors, there are two big factors where prosecutors can constrain political effects, or politics constrains what they do. The first is policy itself. Now remember, in the last episode we talked about how policy is the application of politics in the criminal prosecutorial world. Well, by setting up certain policies, you are by definition preventing the prosecution of other things. So if we are going to prioritize the prosecution of murder, that may mean we can prosecute fewer drug cases. Or if we're going to prioritize ginseng and digging ginseng out of season, then perhaps we can't handle as many stealing cases. So there are always those trade-offs, and policies is a way to constrain people from going too far outside of that mainstream. In addition, we can also prevent assistant prosecutors from improperly using politics in their decision making by how we structure the office. Remember, in episode 4 we talked about how prosecutors can structure their office either horizontally or vertically. If you do significant horizontal prosecution where a case goes from one attorney to the next, it allows many different people to look at the same case, and as a result they are able to prevent improper motivations from dictating criminal prosecutions. Since we've talked about those aspects of policy and structure in other episodes, we're going to look instead at these external factors. What are the external political factors that can constrain what prosecutors do on a day-to-day basis? The first is the jury. Right? Everyone, as we talked about in episode 3, has the right to a trial by jury. It is 12 people who are chosen to serve as essentially judges of the facts of the case. They're to determine what happened in that case. In this role, they play the voice of the community. They speak for the community. They are the community's representative. If a prosecutor were to step outside of what the community thinks is appropriate and start prosecuting cases that the community doesn't think is criminal, the jury has the chance to send that message to the prosecutor by simply saying not guilty, by saying this case is not sufficiently proven, this case should not be coming through the court system. Now, we don't have a system of special verdicts where juries can justify their opinions or they can explain their opinions. They have to convey that simply through the not guilty message that they send. Prosecutor receives enough not guilty verdicts, that message will certainly come through. Juries also have the power to ignore the law. While they may have plenty of evidence before them that indicates the defendant committed a crime, the jury can still ignore that and find the person not guilty. We call this jury nullification. Jurors, for example, in a marijuana case, may say, look, this is not serious enough to be criminal. We think it should be legal. Therefore, we don't care if the defendant was caught red-handed with the marijuana. We're still going to find the person not guilty. That would be an example of jury nullification, but we can see that in cases of justifiable homicide. We may see that in stealing cases. If the prosecutor pursues charges, again, that may be easy to prove, but may not have community support, the jury will return a verdict of not guilty. Now, here's the problem with the jury as a check. Most cases never ever reach a jury. 90% of all criminal cases are going to end up as a guilty plea, which means it's just going to be the defendant going before the judge and admitting guilt. So 9 out of every 10 cases, 90 out of every 100 cases never gets to a jury. But even more than that, cases get dismissed. So the prosecutor may decide they don't want to pursue this particular case anymore. That's another 3 to 5%. And so now we're looking at 5 to 7% of criminal cases going to trial. That's it. That's a very small percentage. If you think about that in terms of a small jurisdiction, if there are only 200 cases that are filed in the course of a year, that means you're only going to have 4, 5 jury trials in the course of that year. Some jurisdictions don't have a jury trial in a criminal case for an entire year. And so the jury doesn't have that opportunity to speak. And if prosecutors build strong enough cases to the point where defendants decide they're going to plead guilty, or prosecutors then dismiss the case before it ever gets to a jury, in most cases the jury never has that power to actually exercise their voice for the community. Even though such a small number of cases actually get to verdict and before a jury, prosecutors still, when they are looking at cases, evaluate them in terms of what the jury may think. That is because a prosecutor can never predict what case is going to go to a jury and what case is not. Therefore, every case they look at, they at least have to keep in the back of their minds that a jury may consider this case. And if a jury's not going to find the person guilty, then shouldn't be wasting their time pursuing that particular case. Now, what comes with that are all kinds of stereotypes and biases that may filter through the community. Prosecutors may stereotype different segments of the community and say, oh, well, this person would never like that case, but they don't have any actual first-hand knowledge. They're not going out and doing polling data to find out, what the community thinks about any given case. They have to do it just based on their own intuition and their own ideas. All right, so that's the jury. In addition to that, there are legislative constraints. So a legislature can impose constraints on prosecutorial decision-making. They can do this in several different ways. Number one is simply how they write the laws. If legislators would remove or repeal laws that they no longer think are relevant or applicable, that would give prosecutors a lot less power to dig up sort of old charges or to use charges that most people may not agree with. In addition, legislators can determine how they draft the law. They can write it very narrowly to cover only a very specific mode of acting. When that happens, the statute may not get used very often. It may be difficult to get a consensus behind it. And prosecutors are very limited in what they can do, so prosecutors tend to oppose that type of statute. Conversely, Congress or legislatures can write statutes very broadly so that it gets at the conduct they want to get at, but they also can be interpreted in ways that covers much more or apply to situations well beyond what the legislature was trying to prevent. This allows it to be very flexible. It can be used in many different situations. The legislature doesn't have to legislate as often, but it also gives prosecutors the opportunity to expand it into areas where perhaps the legislature had no interest in going. Legislatures can also regulate prosecutors through the budget process. Legislators decide how much money goes to the prosecutor's office. And so they can decide, we don't like you prosecuting all these cases, we're going to pull resources from you. We want you to prosecute more cases, we're going to give you more resources. They can also do it by allocating the money for certain purposes. So they may say, we'll give you $1 million, but you can only use that to prosecute and investigate homicide cases. Or you can only use that to prosecute domestic violence cases. And the attorneys who work on those cases can only handle those particular cases. Well, that's going to affect what the prosecutor does, and that can constrain the prosecutor's conduct. Finally, legislatures can conduct oversight hearings, so they can call the representative, the prosecutor, into a hearing and question that person about what they're doing. That gives the legislature some idea of how the particular prosecutor is using the charging power, is how they are handling plea negotiations, whatever may interest the legislature at that particular time. In addition to juries and the legislature, criminal procedure itself provides a check on the prosecutor. The big one, of course, is the burden of proof. Prosecutors just can't file criminal charges against whomever they want for whatever they want. The law requires that they have some basic evidence. Just to file charges, you need to at least have probable cause. If you don't have probable cause, the judge is not going to sign an arrest warrant for the person. If you don't have probable cause, the case is going to get thrown out at the grand jury or preliminary hearing stage. There are judges who read these things. The judges are perfectly willing to throw out cases that aren't based on sufficient evidence. At least, again, on the surface, the judges aren't digging into these cases in significant detail. The second piece of that is obviously the prosecutors have to go before a jury to prove the case beyond a reasonable doubt. If the defense attorney looks at a case and says, look, there's plenty of reasonable doubt here, that case is going to more likely go to trial. The defense attorney is going to make arguments to the judge about why the case should be thrown out. And so those things are also going to constrain prosecutorial conduct. In addition, there are appellate courts. If the prosecutor strays too far out of bounds from what is covered by the statute, then the appellate court is going to throw the case out. We've seen this recently in public corruption cases by the United States government. The U.S. Supreme Court continues to narrow the scope of the laws that prosecutors use to prosecute local corruption cases. They're making it harder for prosecutors to prosecute those cases. And they're doing it simply by looking at cases, looking at the outcomes, and saying, no, this is not sufficient evidence for this particular charge, or what this particular person did doesn't fit within the bounds of this particular statute. Appellate courts are also looking at the procedure. Did the prosecutor commit any misconduct? Did the prosecutor make improper statements about the case? Was closing argument improper? Did the prosecutor fail to disclose discoverable information? Did something that the prosecutor did it violate the defendant's rights in some way? In this regard, the appellate courts again serve a check on prosecutorial use of political power. As I've already referenced, defense attorneys as well play a significant role in checking prosecutorial power. The idea behind this is that defense attorneys are going to actually challenge what prosecutors say and what the evidence is. They need to go through each case and comb through it and find aspects of reasonable doubt and raise those arguments before the court and before the jury. If defense attorneys are continually pleading every single case without looking into it, without creating arguments, then prosecutors will be able to prosecute a wide range of cases without any substantial check on them. And now part of the problem behind this is that there are so many cases going through the system, defense attorneys simply don't have the time or the resources to dig into every single case. And so in order for the defense attorneys to fulfill their role of checking prosecutorial power, they need to be properly funded, whether that's through a public system or through a private system. In addition to the jury, the legislature, criminal procedure, defense attorneys, police have the ability to check prosecutorial power. Remember, prosecutors don't have an investigative arm. They are not investigators. They handle the case in court. It is up to law enforcement to investigate the case and collect all of the evidence. Of course, this leads to a relationship between the police and the prosecutors, but it's not always a good one. And if the prosecutor wants to initiate a policy whereby they're going to arrest all of the prostitutes throughout the city and vigorously prosecute them, If the police don't want to make the arrests, there are not going to be any arrests. There will not be any cases. And so the police and the prosecutors, in order to implement policy, have to work together. And that the investigation has to be done well. In addition, the media plays an important check. We talked about how most cases never make it into public view. 99.5% of all criminal cases go through the system without anybody from the public paying any attention to them because, one, there's simply too many, and B, you'd have to sit in court and watch every single case to be able to do that, and no one has the time or the inclination to simply sit in court and watch what's happening. Some are starting to do that, and that's an important aspect of the court system, but it's not a significant portion of the population that are going and watching court every day. And so the only way that people learn about what's happening in court is through the news media. They have to be able to see, the media has to report on cases. Now, the media is not going to report on every single basic drug case. Right? The media is looking for things that people are going to be interested in, that is going to get someone to click on that story and read that story. And so they know it's the murders, it's the rapes, it's the major theft cases, it's unusual cases, it's the unusual cases. All of these things are going to sort of attract attention. And so when those things happen and the case does become what we call high profile, then people will pay attention, and prosecutors, defense attorneys, and judges alike will all pay a lot more attention to that case and make sure it is done properly without any shortcuts. That's not necessarily going to happen in the other types of cases. And so simply by making a case public is going to constrain prosecutorial conduct in that particular case. Way that prosecutors are judged. So we talked in the last episode about prosecutorial elections. What do people know about their prosecutors? Well, when there's a big high-profile case, they see what the prosecutor does, and that's really the basis for their judgment. And so prosecutors are going to be paying attention to the cases that are in the media and how the media portrays that case and that prosecutor. Now, of course, the media doesn't always get it right. They're not lawyers in most cases. They haven't gone to law school. They don't know exactly how the law works and the legal technicalities, and even if they do, they can't necessarily explain it to a general reading audience with sufficient detail that people are going to understand the different nuances. And so they may get things wrong. They are able to be manipulated. Prosecutors can do things to bring attention to certain cases. They can do things to make certain cases be less appealing to the media and work, behind the scenes on cases. The media can't go into the judge's chamber, so that all they see is what's going to be out in open court. Right? Sometimes that is more theater than it is actual what's going on. In addition, media coverage has a problem. If you give a case too much media attention so that everybody knows about it, if that case goes to trial, now you've biased the jury pool. And that creates challenges for jury selection, and you may lose some very good jurors simply because they happen to watch the news and are familiar with that particular case, and because of the way the media has reported it, that person may have reached a decision about the outcome of the case. And that may hurt one side or the other. And so media coverage can be troubling as much as it is beneficial in some instances. A final piece to all of this is the removal of prosecutors. Right? We can remove prosecutors at election time. We change prosecutors when a new president, or even in some cases a new governor, takes office. But what about in between elections, right? If generally a prosecutor is going to serve for 4 years, what if something happens in the course of that 4 years where the people say, look, this person just can't do the job. This person is unethical. This person is corrupt. This person is incompetent. How do you remove prosecutors from office if they're not doing their job appropriately? Well, if it's an appointing system, you can simply revoke the appointment and pull the person back. Essentially fire them and say, look, you're not doing your job as the district attorney for this particular jurisdiction. I appointed you. I need someone better in this position, or we need somebody better in this position, so we're going to replace you. It happens in the federal system, not frequently, but it happens on occasion where people are going to be replaced simply because they're not doing a good job. Then you just nominate somebody new. But if you're in a system where they have elections, different states have actually legal process that you can go through in order to remove that particular prosecutor. In the Latin, it's a lot of times what they call quo warranto. It basically means that you are instituting a suit to remove that person from office because for whatever statutory reasons, they are not doing their job. So they may be neglecting their position. They're just never in the office. Right? They're not doing their job. They're not processing any of the cases. They're not reviewing the cases. But an argument could be made that if they are not prosecuting a whole category of cases, remember we talked about that in episode 5, then perhaps they're not doing their job, and you could institute an action to get them to be removed that way. In addition, the attorney must have a law license. And so if that person is committing unethical conduct, you can report that person to the State Bar Association or the State Supreme Court, and they will investigate the matter, and they may end up revoking or suspending the person's law license. If that happens, you need to get a new prosecutor because that head prosecutor must be licensed to practice law. In addition to removal, there are 2 other actions that you can take from a legal standpoint that may force the prosecutor to act or prevent the prosecutor from acting. One is what we call a writ of prohibition. You can file that in court. You can ask the court to prohibit the prosecutor from performing some sort of action on the grounds that that action is illegal. So, for example, if the prosecutor announces that they are not going to pursue marijuana cases, perhaps you could file a writ of prohibition to prohibit that policy from taking effect. Conversely, there's an action called the writ of mandamus, which is a action where you take to essentially get a court to order a government official to take an action that they're required to take. And so similarly, if the prosecutor is not prosecuting marijuana cases, you might pursue a writ of mandamus. Of course, the problem with that is the argument is that it's an exercise of prosecutorial discretion. Prosecutors have that discretion to decide what cases to pursue and when not. The problem becomes now, too, where do you draw that line? When do you move from this is a discretionary action to this is an action that's required by law, especially when it comes to the decision not to prosecute a whole category of cases? And so those are generally the political checks on prosecutorial power. You can see there's not many of them. Not all of them are always terribly effective. The prosecutor certainly has the ability to move through those and move around them if the prosecutor is particularly politically astute. But they are there, they do work, and it takes some action on the part of these external actors to really vigorously check prosecutorial political power. Otherwise, again, prosecutors are going to be working without any accountability, and that is when they begin to act in ways that we as a society don't want them to act. And so that wraps up our look at the interaction between politics and prosecutors. We have several podcast episodes out there on the Politics of Prosecution Podcast. We will continue adding to those as we progress. This provides you with a good foundation for what we're talking about in those cases. A lot of times we're going to look at really specific examples and we'll apply these principles to those things. In addition, we'll look at how this stuff plays out in our Politics of Prosecution video series. We hope to have an episode out for that very soon. We're at work on our second case study for that, and you'll see those also on this particular YouTube channel. Be sure to follow or subscribe to this YouTube channel to get all our video material. In addition, you can follow us on Instagram at poly.n.pros, P-R-O-S, or on Twitter at poly, P-O-L-I_PROS. Be sure to follow us there for all our announcements. In addition, you can, of course, find the podcast on Spotify and iTunes. Thank you for watching this series. We hope you found it was informative and interesting. If you have any comments, questions, concerns, or criticisms, you can find us on Gmail at poly.n.pros@gmail.com. Thank you very much.